Good afternoon. I'm James Vann with Vann Attorneys, and we are really glad that you have signed up for this webinar today. We do these free of charge, and in fact, we get a lot of clients that ask us to come do a presentation at their business, right? So if you ever want us to do that, be glad to, but we do this to help you. Hopefully you will gain some information that will help you in your business. And if you have questions today, please send them to us by email at webinar@vannattorneys.com, or you can use the GoToWebinar control panel and submit your questions that way. Also, just one more piece of information for you. We're going to be hosting our next webinar on July 31st. And if you have a topic that you want us to cover, we would love to hear from you. I know we get some of those from clients occasionally, and it's really helpful. I will tell you today, this is obviously a very pertinent topic because we have had a great response. So this is obviously something that you are wanting to hear about. So we look forward to hearing from you if you have questions, and we're going to get started here in just a few minutes. So we're making some adjustments on the screen, so bear with us just for a moment on that. So hopefully we're ready to roll. So you can see on the screen some of the topics for discussion. How do you protect your business when you're owed money? And yeah, it's really interesting, right? I know a lot of you who have signed up today, and a lot of y'all have a lot of great years of experience. And you know, it ebbs and flows, right? So it's one of those things that the economy, depending on what's going on, it really does make an impact on accounts receivable and people's mindset of when and how to pay. So this is obviously a hot topic because this is one that we've had great attendance in. We're going to look at what options are available. I know most of y'all know what promissory notes are. How do you have what's included in a promissory note? What do you have to have? Why would you have one? Right? Would you have a payment schedule? And then also we've talked about over the years confessions of judgment. Great way to, as I use the phrase, have your customer or the person that owes you money to put their money where their mouth is, right? And then obviously another way of getting security or collateral for that promise is a deed of trust. And then we'll also look at some other collateral. So hopefully those things will make sense to you, right? So how do you handle getting money from, right, a customer that you value, right? And it's who knows why they're not paying it, right? Sometimes it's cash flow on their end. You know, I bet we all know people, or you may have experienced this in your business, where they may be impacted by their cash flow. And I've heard a fairly decent handful of clients that have talked about some of the changes in the federal administration with how they are distributing dollars, that it's having an impact in some sectors, right? So that's something that it can be impactful, right? But it could be that your customer lost a big customer of their own, or they haven't been paid, or who knows, right? We could go through a whole list of stuff that, you know, divorce within the company, right? That happens a lot, right? If one of the owners, you know, or the owner has a divorce or a death in the family, right? All of those things can impact your customer's cash flow. But, you know, what I would encourage you is remember, it's a business transaction. This is not personal, right? Keep a great relationship with your customer. Keep the communication open, right? This should not be a relationship ending transaction necessarily, right? There's sometimes you go, yeah, I'm done, right? And that's certainly a decision you get to make. You know, and I've heard this over the years with some of you, right, in helping you collect money, right, where the customer says, well, you know, we're going to come after the creditor because they've stopped doing business with us. Well, that's our choice, right? And you have that choice. You don't have to do business with them. So it doesn't have to necessarily end. So let's look at promissory notes in North Carolina, right? So a prom note really is a contract. It's between the lender and the borrower, right? And it's for money that is due. That's payments that are going to be made, right? And there's a loan, right? And it can be secured or unsecured. I will say this, right? And over the years, we've looked at thousands of promissory notes probably. And sometimes, right, people will use a promissory note that the form is not very good. So I would highly encourage you, call us, call another attorney if you're dealing with anybody else, and ask them for a promissory note, right, that they have used or they can talk to you about. And sometimes I know you can get them. I know you can get them online. I know that, right? AI or you can buy the forms online, right? Make sure that there's the North Carolina Bar Association used to publish one, and I think there was a fee for it, a small fee. But a lot of times you'd see it on the bottom, right, that would say this is a North Carolina Bar Association form, not the bar, state bar, but a bar association. And that was a form that many, many lawyers had worked on to make sure that it included what was needed. There are times now when, I mean, you could draft one yourself, right? You don't have to buy a form. You just want to make sure the right terms are in it. There are a lot of times when we will get calls from client, or not clients, but prospective clients necessarily, who have lent money to, maybe it's an individual relationship, and they use a prom note or what they thought was a prom note, but sometimes those are really helpful, and sometimes they're just really bad. Sometimes you got to jump through some extra hoops if it's really bad to try to prove it. So it's a lot better if you use a tried and true form, right? So in North Carolina, for a valid and enforceable promissory note, you need to have the following, right? It needs to be dated, right? What's the date of the note? And identify the parties, right? And not just it shouldn't be just, J Vann, right? Or J.R. Vann. Use the full name if you can, or James Vann, right? Whoever you're lending the money to, right? Make sure that you've got their full name, right? Or their real name. Growing up in a smaller town, right? Some people had nicknames, right? Don't use the nickname, use their birth name, right? And if it's a company that's borrowing the money, you want to make certain that you use I would say go to the Secretary of State website, look at it, try to figure out what the real company name is, and make sure that you're using that name, right? List the addresses for the parties, right? The amount that's due. Think about what interest you're going to be charging, right? How's it calculated? And there are interest provisions in North Carolina that are capped depending upon what your business is or what the loan is for, be it whether it's a business or individual. And then how is the money going to be repaid, right? And when is it due? Also, we would really encourage you to use a provision for reasonable attorney's fees. And if you had to use an attorney to go and collect the funds, at least you have a recourse in getting some of those fees included in the judgment or collected under reasonable attorney's fees. And then what terms when is a default declared, right? Is it 30 days past due? Is there a time for cure for the debtor? If the person signing the prom note misses one payment, do they have a right to cure and to catch up, right? And then make sure that the borrower actually signs it, and also get it notarized. Sometimes, we get some documents from folks, and it's any of these things, right, could be wrong, and it just creates more extra cost and actually time to get that stuff enforced. But anyway, that's sort of the things that we would encourage you to have in your promissory note. So, a lot of times people will say, look, got a customer, I've sold a product or service or whatever, however the debt arose in the business, right? And then all of a sudden they haven't paid you. And then people say, well, can I sue for that? Well, yeah, absolutely, you can. That's a contract, right? You already had a contract between your business and your customer's business for the monies that are owed for whatever, however it came to be. And then, when we reach out to some clients used to say, hey, look, can you get our client under, or customer under a promissory note, right? Get them to sign. Well, that's just one more contract. You already have a contract, and getting them to sign a promissory note is really the second contract that they've already breached the first one. So I always suggest, if they're willing to pay, which hopefully they are, let's get them to do a confession of judgment. And so the difference is, it's when they are obligating themselves to make payment, and we'll do a payment schedule with it. But it's where I say you put your money where your mouth is. If you're telling me the truth that you're going to make the payments as you have promised, then the confession of judgments basically says, I, the debtor, know I owe the creditor X number of dollars, and I'm willing to pay it back in the following manner. And once I do, then you can destroy the confession, and it's not filed, right? Under most payment schedules. You could file it if you wanted to, but most of the time the debtors don't want you to. And a lot of times it's a great tool to have the debtor have some encouragement behind the debtor to make sure they do pay it. Because if they don't pay, then you can file it, right? That's what happens a lot of times. And so when you get the confession of judgment, you don't have to sue them, right? It's already a judgment. Once you get it and they have signed it, if they don't pay as they've promised, you file it with the clerk's office. You don't have to enter into a lawsuit. It reduces the cost a great amount, and you already have a judgment. Now, one of the negatives of taking a confession with a fairly long payment schedule is, let's say, for example, that you get a confession of judgment and you say you take a year payment schedule, right? Because the debtor says, I don't have the money to pay you all of it right now. Well, if that happens, and then let's say the debtor in 3 or 4 months either dies or files bankruptcy or sells all of their assets, right, so that they're basically judgment proof, then that doesn't help us, right? It doesn't help you, and that hurts. So those are the risks that you take as a creditor in taking a confession of judgment, not filing it, right, and then holding on to it while you're getting the payments. Just a little tidbit to think about, right? So the confession, again, is it's a legal document, right? It's without a lawsuit. It's agreed to by the debtor, and it's in writing. They sign it and agree to it. It's notarized, and it typically includes a payment schedule. And again, all of these things are negotiated as far as how it's going to be paid, when it's going to be paid, and so forth. So again, it's a great way of asking the customer to sort of guarantee, if you will, or I should say that's a bad word, excuse me. So it's a way of having the customer to own up to the fact that they're actually going to pay it the way they say they're going to. The taking the confession of judgment, right, is a good way to, I think, put it in writing. If the customer says, look, I'm not going to sign that, but I'm going to make the payments, I would tell you they probably aren't going to make the payments, right? That's what we have seen over the years. There's certainly some that do, but a lot of them, if you don't have the stick holding behind your back, right, they don't feel it, and they may not, if money gets tight, they may not make the rest of the payment. So just something to think about. Again, includes a payment schedule. It's not filed, detailed as far as the amount due, the date of the payment, where the payment should be made. It very much mimics a promissory note, but it has teeth in it, if you will. I love it because it's cost effective for our clients, right? And timeliness, it helps you because you don't have to go through a lawsuit, right? It eliminates the further delay by the customer. And again, it's not just another promise. It's a promise with teeth, if you will. So how do you secure the debt for payment, right? So, and when would you want to do that, right? So securing it with real property. One reason we love for clients to get their promises secured with real property is it's really difficult to hide the real property. You can't run off with it. You can't hide it. And it generally does not depreciate in value. It typically appreciates. So if you take debt, if you have some debt that the customer owes you and you get a collateral with real property, hopefully there's enough equity in that real property that you'll get paid if you have to foreclose. So again, it's getting real property, again, is voluntarily provided by the debtor, right? They have to agree to it. And we help clients with this quite often. And so what we'll do is actually do a little mini title search to make sure that the property, to see what liens and judgments are already on the real property so that you know, okay, the property is worth, $500,000 and it's got, two deeds of trust for 250. So it tells you debtor's got at least $250,000 in equity. So gives you a little bit of guidance with that. The taking a deed of trust is noted in a deed of trust against the real property, and it's filed with the Register of Deeds office where the county is located. So again, that's how that security part of it works, right? What are some of the pitfalls of that, right? Well, the debtor may not want to commit the real property to collateral, as collateral. It sort of ties up their property, but also you got to make sure you know who owns the real property. They have to sign the promissory note as well. It does restrict the free transfer of the property by the customer or by the debtor if you get a deed of trust and you file it. So, but again, we love it because if they go into bankruptcy, at least in the bankruptcy, you'd be declared as a secured creditor. Now they could play with that and try to get that undone, but the good news is you got a fighting chance of being a secured creditor in bankruptcy, which has a much higher chance of getting paid in bankruptcy. Generally, it provides, again, we said collateral, right? Assuming the equity in the real property. The value of the collateral doesn't change rapidly, right? If it's wrecked like a car, the value goes down pretty quick. Thankfully, that doesn't happen with a real property. And the debtor can't sell it without making the payment or making sure that the creditors get paid. Sometimes we have used credit line deed of trust for our client, depending on the relationship. It really provides for security for an open account. And for example, let's say you've got a customer that has a running open account with you, and they're buying it all throughout the month and making a payment, and that just continues and revolves. Well, what happens is you find property that has value. You do a credit line deed of trust for, let's just say, for example, up to $500,000. And that there's a deed of trust that's filed for up to $500,000, and you just have it's just basically in and out, but it gives you collateral and security if they don't pay, which is really what you want. Again, it's given by the debtor or the customer or the property owner voluntarily. It gives great flexibility in the revolving line for the debtor's balance as it goes up and down. Again, not every customer you're going to ask for in this, but there could be times when this makes sense for you. It actually is a deed of trust against the property, and it's filed, right? So it's a great way to protect future purchases, and also it helps protect you and your customer if anybody's having cash flow problems, right? Because you got some collateral, you always got that to go against if they don't pay you the way they promise. So what about accepting vehicles as collateral? Is that a good thing or bad? Well, again, it's voluntarily given by the customer, and it gives you some degree of security. As you all know, you can hide a vehicle, right? The vehicle can get stolen. It could get moved to a location where you can't find. It could be wrecked. It's just a whole host of things, right, with a vehicle. We had one client a number of years ago who would routinely take collateral in vehicles. And I happened to be at their office one day, and we were talking about this, and this credit manager opened the drawer, and there was a stack of vehicle titles that had never been filed with the North Carolina Department of Motor Vehicles. And I'm like, what are you doing with that? And they said, well, we get collateral in vehicles, and I hold them here. And I'm like, but you're not filing them. She's like, no. I'm like, that's no good, right? Because what happens, the customer could, even though they've given you the original title, they can go to the DMV and get a replacement title and then sell the vehicle, right? And then your piece of paper that you have in your desk drawer is of no value. So we had a long conversation about that. So if you're going to take collateral in vehicles, you want to make sure on the back of the title that the owner of the vehicle lists you as a creditor or a lien holder, and that's actually filed with the DMV. That's really important. So a little side note there, right? It's, again, you gotta make sure you document it. it's recorded as a lien on the vehicle, and as long as the vehicle is around, they have it. You got a lien, right? If it's destroyed by whatever causes, then you really don't have any security at that point. I will tell you a very interesting story. We had another client who took a title in a vehicle, and the person who owned it lent the vehicle to, I think, their niece, who lived in Massachusetts. And we were trying to get the vehicle. It was so difficult to get the vehicle because multiple states, they were hiding the vehicle. It was a pain. So eventually, thankfully, the niece came to visit the customer. Our client had to pick up on it, and they were able to secure someone to go over there and pick up the vehicle before the driver decided to leave the state. I just tell you that because that's just realistic issues that happen with taking vehicles, right? Again, debtor may not sell the vehicle without your approval if you've got it documented on the back of the title and file it with DMV. And also you can do this with equipment, right? Heavy equipment if they operate that as well. Again, there's a questionable issue about value sometimes. The collateral value can change pretty quickly, so you got to make sure that you're monitoring how much they owe you and what the vehicle's worth. So you can tell vehicles are okay, but there's some downsides to it as well. And sometimes people don't have any other assets. That's what they have, right? Most people do have a vehicle. So it's easy to obtain the collateral by completing the lien on the back. And then you can send that in, so it gives you some protection. So what about foreclosure proceedings if you do have a deed of trust? Well, on the foreclosure, you're basically selling the real property to satisfy the debt. And it's controlled by the promissory note and the deed of trust. And in North Carolina, it would be controlled by North Carolina law as well. You've got to follow the procedures to ensure proper protection of yourself, but also of the debtor. So think about a funnel, right? The big end at the top, small end at the bottom, that's where the money flows. If you're the first deed trust holder and you foreclose, let's say you foreclose and the sale of the property produces a greater price or value than what you're owed, then you get all of what you're owed, and the rest of the money either goes to other lien holders below you or to the property owner. So that's how you don't get a windfall of all of it, right? But that's how it works. And then the procedures, you've got to give written notice of a foreclosure, and then you got to give them an opportunity to cure that default. And then you got to file suit to begin the foreclosure procedures, give notice, and then there's other steps you got to take to give the debtor proper notice, and then to make sure that the property is properly advertised for the foreclosure. And we do some throughout, right? Most of the time, if there's a deed of trust and the people obviously know they've issued or signed that over to the creditor, it's a great incentive for folks to actually get you paid. I bet you we haven't foreclosed on, I don't know, 100 or 200 in the last several years. Because most people will pay, right, when they have to, if there's a creditor involved in like a confession of judgment or something of that nature, right? We don't do the foreclosures, for example, for banks, or we don't typically handle that piece of it, but those could be certainly a lot more susceptible to foreclosure than the things we typically represent. So again, make sure you document your agreement for repayment. Document that as best you can. Use the tools that you have, right? Keep the customer on track for payment. And I know many of you on here, y'all follow up with the customers. You send reminders. You make it easy, right? And there's generally a lot of grace too. I know. Again, don't let it get to be personal. It's business, right? It's just a business transaction. They need to pay for it. And then enjoy your moments, right? Enjoy those opportunities that you get a chance to. We really hope that this is helpful to you. If you've got questions, if you've got folks that owe you money and you just want to run it by somebody, you're welcome to pick my brain or any of our brains here. We'd love to help you. Again, we look forward to participating with you on our next webinar on July 31st. And we don't talk to you before that. Hope you have an awesome Independence Day. Thanks so much.